Hi there, and welcome to the PSRB Lawcast. I'm your host, Adam Wright. Each episode features dynamic conversations with attorneys from the law firm of Pellegrini, Seeley, Ryan, and Blakesley in Massachusetts, along with special guests discussing a wide range of topics relevant to personal injury law. Remember, every case is different, and in order for us to provide you with accurate information and advice relevant to your specific circumstances, it's important to set up an appointment with one of our attorneys to meet in person. Today, we're going to spend a little time touching on some of the lesser known and lesser used sections of the Workers' Comp Act, but these are truly important aspects that could arise in a workers' compensation case. And to help us out once again, we turn to PSRB attorney Dan Blakesley. The focus of Dan's practice is within various areas of personal injury law, in addition to advocating for injured workers before the Department of Industrial Accidents. Dan Blakesley also represents clients who have been injured through medical malpractice, car accidents, slips and falls, and other kinds of accidents. Hey, Dan.
Hi, Adam. How are you?
I'm good. So, we talk a lot about workers' comp in a general sense here, but there are a few areas within workers' compensation that do come up as potentially infrequently, but they are still really important things to talk about. One of them, and I know we just had a case about this not long ago at the firm, injuries caused by employers' serious and willful misconduct.
Yes.
Tell us a little bit about what constitutes a willful misconduct case.
Well, the whole purpose of this section of the Act is kind of a direct response to the idea that once workers' compensation was enacted by the legislature, the injured worker could no longer sue their employer, even if their employer's actions caused the injury.
And that's a huge misunderstanding with a lot of people that come to the firm.
Sure.
They think they can sue their employer.
Right. It's hard for people to come to grasp with, but you have no rights to anything other than workers' compensation if you're injured at work, even if your employer caused the accident. That's the trade-off for having access to workers' compensation, regardless of fault. Conversely, if you're hurt doing something stupid at work that you shouldn't have been doing, typically that's covered as well, with exception. But you cannot sue your employer after having a workplace injury, even if they were negligent and that negligence gave rise to the injury.
Now, let's just tell people why not, where that money comes from that does pay them for workers' compensation. It doesn't come from the employer per se, except they buy insurance, right?
Correct. And the trade-off is that employers now were forced, when workers' comp was enacted, to provide workers' compensation insurance, which was a huge expense for them. So the legislature recognized that they were making a sacrifice and also put into the act that they could not be sued. But over the years, there were certain cases where the conduct of the employer rose to more than just mere negligence. And the legislature enacted Section 28 of the Workers' Comp Act, which is what we're talking about here. Section 28 reads that if the employee is injured by reason of the serious and willful misconduct of an employer or any person regularly entrusted with and exercising the powers of superintendents, the amounts of compensation hereinafter provided shall be doubled. That means that if you show that the employer's actions rose to the level of what they consider a quasi-criminal act, intentionally doing something either with the knowledge that it is likely to result in an injury or with a wanton and reckless disregard of its consequences, and somebody's hurt, then if that is proven, the person is entitled to not only double the weekly benefits that he or she receives in their claim, but the insurance company would actually have to write them a check for the amount of any medical bill that they covered. Once they pay the medical bill, they have to write a check for that amount to the injured worker.
So what would an example be of serious and willful misconduct that the statute is applied to?
There isn't much out there, honestly. A lot of times clients are upset because their employer has failed to maintain some aspect of their machinery or has kept a disorderly workspace or has failed to discipline somebody that they knew was operating something unsafely, those situations are almost always pure negligence. The law has treated Section 28 as a situation where you really need to show what they call quasi-criminal conduct or intentional conduct. Examples of what has been found to meet the criteria of Section 28. There was an older case involving an inexperienced foreman who got into heavy equipment and started operating it at max speed, despite the fact that he didn't have a license, and he hurt somebody. And that was a Section 28 case. There was a case involving a trench collapse where they had dug down lower than 8 feet and didn't put any shoring in, despite the fact that it was required by construction standards. That was found to be a good case under Section 28. The ones that we most often see are ones in which a supervisor physically attacks a subordinate. That's clearly an intentional act and a willful act that would rise to that level. Although those types of situations can be heavily contested just based on the superintendent's aspect. I had a case involving a kid who was a landscaper, and he was working on a crew that was semi-supervised by another coworker, but he was regularly entrusted with being a supervisor during certain job situations. And this was the guy that attacked my client on that day. That case didn't go to a full hearing decision, but I believe that he was entrusted enough with the powers of superintendents to where he would be a supervisor, and the employer would be on the hook for the double compensation contemplated by Section 28.
What do you think about, I mean, so willful misconduct would not apply to, let's say, deferred maintenance on a machine to save money, knowing that the machine was unsafe?
Most of the time, no. A failure of an employer to act on something like that could potentially be the basis for a Section 28 claim. My understanding is that there would have to be a prior admonition. In other words, the employer would have had to have been disciplined for that in the past and failed to act on it. The most common example would be an OSHA violation that they were penalized for. Contrast that with a situation where an employer has a piece of dangerous machinery that they remove a guard from. In that situation, that's much more likely to be serious and willful misconduct because they took it upon themselves to remove the guard, and they knew that it would increase the chance of a serious injury.
Is this something that has to be adjudicated separately from a workers' comp claim, or is it kind of all rolled into one? In other words, do you first try to establish that your client needs compensation for a work injury, and then you go after Section 28, or is it all sort of done at the same time?
You could do it both ways, but it's probably best to bring in the Section 28 component earlier in a claim. Now, a lot of times a claim is denied and you're trying to get a person in front of a judge sooner than later and don't want to deal with the procedural aspect of bringing a Section 28 claim. But the sooner the better, because the 28 claim is actually a claim directly against the employer. The employer has to hire their own counsel. They have to go through all of the procedure that an insurance company would before you get in front of a judge. When you're in front of a judge, you really want all your ducks in a row, so there's no further delays and the case can be properly adjudicated.
Another issue that does come up, though rare, but I know it does, is suicide. When somebody gets hurt, there's a real mental component to this. They're in pain. They've lost their income. Maybe they've lost their status because of the job that they had. And suicide does happen on occasion.
Sure.
Are there statutes that would address compensation for someone that takes their own life because of their injury?
Sure. Yeah, the Workers' Comp Act does contain a section that does consider suicide. It's Section 26A. But it must be shown by the weight of the evidence that due to the injury, the employee was of such unsoundness of mind as to make him or her irresponsible for their act of suicide.
It's got to be a very difficult thing to prove.
It can be, and it does not come up in the vast majority of cases, thankfully.
Thankfully, yeah.
But it can be a very difficult case. I myself have only had it come up once in my practice. It was a pretty heartbreaking case. My client was a collector for a newspaper company. And at one of his stops, he went into a store, slipped and fell, and struck the back of his head on the floor. This was about his fifth or sixth concussion over the years. And as we know, concussions can have a compounding effect, with each one being worse than the next. Well, this poor guy, in the aftermath of this accident, became increasingly paranoid. I could hear it on the phone calls. He was trying to say that the phones were tapped. He was becoming increasingly erratic. And I started worrying about him. And then one day I got a call from his wife that he had taken his own life. And in speaking with the wife after he committed suicide, it was clear that his behavior was night and day from what he had exhibited prior to the fall at work. This guy started boarding up all the windows and doors at night. He would make his wife and child lie in bed with him motionless for hours at a time. He became convinced after a number of months that the souls of his wife and child had left their bodies, and what remained behind was some form of evil. Wow. And their souls had been taken by a rapture. His wife actually gave me a 19-page affidavit describing all the behaviors that this guy was exhibiting in the time leading up to his death, and ultimately ended up taking his own life.
What a tragic story.
It is.
What kind of compensation is available for the survivors of somebody like that?
Well, he had a wife and a 14-year-old child at the time, and those are dependents that would be entitled to death benefits if we were able to show that the injury at work ultimately led to the suicide. And the connection could clearly be drawn. We filed a claim for that. And I hired an expert who was a board-certified neurologist and a board-certified psychiatrist. This doctor looked at the affidavit, looked at the medical records, indicated that, yes, this gentleman did have a concussion that was made worse by the fact that he had a history of prior concussions, and his mania and delusional behavior and paranoia after time went by after the accident was a direct result of the head injury. And he diagnosed him with something called Capgras syndrome, which is almost a phenomenon within psychiatry where people come to believe that the souls of their loved ones have been taken, or that aliens have abducted their loved ones and that they've been replaced with some other type of being. And it's a form of paranoid behavior that often will result in the individual taking other lives and not just their own. And that was this doctor's, that's what he found most surprising about this particular case, was that it was just...
they were often murder-suicides.
Correct. Yeah. So it could have been even worse than it was, despite the fact that this poor teenage boy and his mom were left without their dad and husband. But it was a case that ended up settling. And it settled because the lawyer on the other side knew the law very well, and he had great respect for our evidence and our doctor. And interestingly, the security guard at the Department of Industrial Accidents knew my client. And the first time he walked in for his first conference, when his claim was in dispute and we were fighting for his initial benefits, took one look at him and said, "That is not the person that I know. That's a different person." And he barely even interacted with him. So, it shows the profound effect that head injuries can have on people. And this case was a tragic but, extreme example of that.
We're talking to Dan Blakesley about some of the lesser known or yet lesser used areas of workers' compensation law. sometimes when people are hurt and they're out for a very long time and they're collecting workers' compensation, had they been working, they would have naturally been eligible for an increase in pay, or just a regular cost of living raise or a merit raise or something like that. How does the Workers' Compensation Act address that issue?
There is a way that an injured worker under limited circumstances can increase their average weekly wage under Section 51 of the Workers' Comp Act. Now, Section 51 says that whenever an employee is injured under circumstances entitling him to compensation, if it be established that the injured worker was of such age and experience when injured that under natural conditions in the open labor market, his wage would be expected to increase, that fact may be considered in determining his weekly wage. That's been interpreted pretty narrowly. It does not apply to most cases. Most often, Section 51 will bolster the wages of somebody such as an apprentice tradesperson who's injured in the very early stages of their career while they're learning their particular trade. But the injury prevents them from continuing to learn that trade, obtaining licenses, and building their ability to earn money, or perhaps go out on their own and open their own business. It can't just be that you were working a job and are going to be losing out on whatever raises come through. You have to be in a position where, under natural conditions, but for the injury, you would have expected a significant increase in your average weekly wage through just passage of time and continuing on in the field.
Makes sense. And certainly, I would think that that does happen a fair amount, especially with younger guys who are in situations that could be potentially dangerous, welders or plumbers even, or construction guys.
Sure. I mean, consider the apprentice making $20 an hour that a year from then, once they got their license to go out on their own or become part of the union, would get a jump in pay to $50 an hour. That opportunity is no longer available to them simply because they were hurt at work and can no longer perform that job. And I think the legislature recognized that situation when they enacted Section 51.
Well, these are really interesting components of the Workers' Compensation Act. And, again, they're rare, but they're important to know. And, of course, as always, if you have any questions about your injuries or how you could potentially file for workers' compensation and what may be available to you, we hope you'll give Dan or one of our other attorneys a call here at 800-785-5399, or you can go to our website at psrblaw.com. Dan Blakesley, thanks so much.
Thank you, Adam. Thanks for having me.